Welcome to the BRBL Crash Course. This is our unit number 29, LLP Act 2008. Questions are asked based on this particular chapter. So we will see what types of questions are asked in the basic term, easy to understand manner using flowchart and diagram. So first of all, let's understand the structure of the LLP, that is Limited Liability Partnership. Let's break down the key part that make an LLP work smoothly. First of all, we have designated partner. An LLP must have at least two designated partner. Out of these two, one must live in India, and if the partner is a company, a nominee must be appointed to act on its behalf. So first of all, key point, remember, two designated partner. Out of these, one must live in India, and if the partner is a company, the nominee must be appointed to act on its behalf. Then we have the minimum partner. You need at least two partners to form an LLP, at least two partners. If only one remain for more than 6 months, they become personally liable for the firm obligation. At least two partners is required. If only one remain for more than 6 months, they become personally liable for the firm obligation. So 6 months. Personal liability after 6 months of carrying business alone, as per the section number 6. Minimum two partner and personal liability after 6 months. Then we have buddy corporate. What is buddy corporate? An LLP is a separate legal entity. That means it continue to exist even if the partner change. That is called perpetual succession. Perpetual succession means LLP is a separate legal entity. It continue to exist even if the partner change. Now what about the partners? See, individual or even company can be a partner in LLP. Individual or company can be partner in LLP. However, there are few restrictions. Like a person can't be a partner if they are insolvent, if they have unsound mind, if they are legally restricted from doing so. So individual or even company can be a partner, right? So this structure ensure that LLP are flexible yet legally sound, simple, efficient and modern. So at least two designated partner, one must be resident in India, and then minimum partner, at least two partner is required, and sole partner liability after 6 months of carrying business, and it is a separate legal entity. Perpetual succession, right? I told you that LLP is a separate legal entity. It continue to exist even if the partner change. Perpetual succession. And partner, individual or even company can be a partner in LLP, but some restrictions are there. Now have a look at the next slide, LLP partnership structure. So friends, let's look at how LLP partnership is structured and how partner work together. The first one is the eligibility. You can see. So only those involved in setting up the LLP or called incorporators can be a partner in the beginning. So what I am telling you, only those involved in setting up LLP, they are called incorporator. So incorporator can only be partner in the beginning, other can join later as per section 22. So who are incorporator? So those who are involved in setting up the LLP is called incorporator. Section number 22, please remember it. Then we have something called partner, pre-incorporation agreement. Have a look at it. Just wait. Yes, here you can see pre-incorporation agreement. Try to understand. Before the LLP is officially registered, the partner may agree on some terms, and this agreement must be confirmed by all partners after the LLP is formed. So what I am telling you, that before LLP is registered, before the registration of LLP, partner may agree on some terms. There are some terms on which they may agree, and the agreement must be confirmed by all the partners after the LLP is formed. That is called ratified by all the partner post incorporation. So those agreement from on which before the registration of the LLP some terms were there, so agreement must be confirmed by all partners. Then we have LLP agreement. What is the meaning of LLP agreement? This is the most important document. It clearly defines how the LLP will be run, the role of each partner, how decision will be made. It is about LLP agreement. It is governed under section number 23. Then agreement change. Any update, any change to the LLP agreement must be filed with the registrar to keep things official and legal. And then we have first schedule provision. If there is no LLP agreement, don't worry. The law provides default rule. There is a default rule. These are called first schedule provision, which ensure that LLP still work smoothly. So what we learned, first of all, eligibility. I told you that only those incorporator who are involved in setting up the LLP can be partner in the beginning. Other can join up as per section 22. Pre-incorporation agreement means before the LLP is officially registered, the partner may agree on certain terms, and the agreement must be confirmed by all partners after the LLP is formed. Then we talked about LLP agreement. Most important document it is. It defines how the LLP will be run, the role of each partner, and how decision will be made, governed under section number 23. Remember it. partner relationship. Then we have agreement change. Any change in the agreement, any update in the agreement must be filed with the registrar. And the first schedule is, suppose there is no agreement, no LLP agreement, don't worry. The law provide default rule, and these default rule are given in the first schedule provision. Now friends, have a look on the cessation of partnership. So what is the meaning of cessation of partnership? So cessation of partnership, have a look at it. So when a partner stop being a part of limited liability partnership, it is called cessation of partnership. What is the meaning of cessation? Suppose a partner, right, stop being a part of LLP. This is called cessation of partnership. Let's break it down. First of all, we have resignation. A partner can leave by giving a 30-day notice or through mutual agreement with other partner. So two way, either they give 30-day notice or they through the mutual agreement with other partner. These are two way of resignation. Then we have something called forced cessation. Sometimes a partner must leave due to death, insolvency, mental illness or court order. Section 24 subsection. Now friends, one more thing, obligation does not end even after leaving, right? Even after leaving, the partner is still responsible for any earlier duties or any promise made within the firm. This is called obligation. Then we have entitlement. The former partner has right to get back their capital and share in profit after losses are adjusted. Then we have the no more management right. When a partner exits, they can't interfere in the management of the LLP anymore. So to summarize the cessation of partnership journey in the LLP, but the responsibility and right are carefully protected by the law. So just let me revise you once more. First of all, resignation. So basically resignation, they can leave by giving a 30-day notice, right? Second point is forced cessation, which means sometimes a partner may leave due to death, insolvency, mental illness. Then formal partner status, until proper leaving, until proper notice is given to the other partner, the person is still considered a partner. Obligation does not end. And entitlement, right? So they have the right to get back their capital and they cannot interfere in management. So these are the important points. Now have a look at the conversion to the LLP, conversion to the limited liability partnership. Very, very important. So if you want to turn your business into LLP, let's see how easy it is. So you will get to know from this particular slide how easy it is to turn your firm into LLP. So first of all, you can convert different types of business entity into LLP. Let's see the path. First of all, firm to LLP. If you are running a traditional partnership firm, you can convert it under Chapter 10, second schedule of the LLP Act. So firm to LLP can be converted under the Chapter 10, second schedule of the LLP Act. Then private company to LLP. So if you own a private limited company, so conversion is possible under Chapter 10, third schedule. And if it is unlisted company, so even unlisted company can become LLP by following Chapter 10 fourth schedule. So firm can become LLP, private company can become LLP, unlisted public company can become LLP, and there are different chapter, different schedule. And once the correct process and a schedule is followed, the conversion is complete. Now you are an LLP with limited liability and flexibility in operation. So this conversion brings more protection and professional structure to your business without losing control. Now have a look at LLP conversion and compliance. Very, very important. Let's understand what every limited liability partnership must follow after formation or conversion. First of all, we have is the registration. Let's look at the bottom. First of all, we have is the registration. So when an entity convert into LLP, it must register under section number 58. Right. So section 58 says that registrar may update the name, registrar update the detail in the official record. Right. So you can see registrar role is there. They register LLP if condition in the second, third and fourth schedule are met and a specific date LLP is registered, right? And then LLP must inform its old authority like registrar ROC within 15 days, right? So earlier it was a firm, obviously it will have registered, so that particular LLP, that particular firm which has converted to LLP, it must inform its old ROC within 15 days of registration. Partner, shareholder bound by the relevant schedule. So this is about LLP registration. Then we have conversion effect. See, after conversion, the LLP legally replaces the old entity. So LLP legally exists, right? LLP legally replaces the old entity. All asset, all liability, all right, all obligation move to the LLP. And the old company or old firm is removed from the record. So this is called conversion effect. Once an LLP get converted, what happened? LLP legally replace the old entity, all asset, all right, all liability moves to the LLP and the old company or firm is removed from the record. This is called conversion effect. Now annual filing, section number 34. LLP must file a statement of account and solvency every year. It must be filed within time or there will be penalty. That is called annual filing of penalty. A statement of account and solvency every year. It must be filed by LLP. It must be filed within 1 year. Very, very important time period. Within time, sorry, not 1 year, within time, or there will be penalty. Then we have audit standard. LLP must follow proper accounting and auditing standard. These are set by the government or NFRA under the law. Then we have the penalties. So as per the section number 35, any delay in filing the annual return after 1st April 2022 attract a fine. What is the fine? 100 rupees per day for LLP and designated partner, right? Same 100 rupees per day. Maximum it can go to 1 lakh for LLP, and for designated partner it can go to 50,000. So if you have no cap, more delay, more penalty. So basically I hope that is why stay timely, stay compliant. LLP must follow these rules to avoid trouble and keep operation smooth. And that is all you need to know from unit number 29. Very short topic, very small topic it is. I have covered almost all the important points from LLP. Just go through this particular PDF one. If you want get such kind of PDF, you can enroll in our capsule crash course program. For more detail you can see the description section. Thank you.